Listen to the voices of the advocates.
Welcome to Advocates, the podcast, where you get to listen to the very best talent in the world. Lady Hale opened a famous judgment of hers with these words about our guest today. Jonathan Crowe, QC, she said, counsel for the respondent boldly asserted at the outset of his submissions that this case is in fact bristling with simplicity. The issue, she continued, certainly is a simple one. Those words will no doubt go down in legal history. What you will find out in this interview is not just how bold Jonathan Crowe is, but what a captivating subject for an interview. Jonathan, welcome. Jonathan, thank you so much for being with us. Let me start with the beginning. Where are you from?
Born in London, but oddly, my first memories are in fact in Morocco. My father was in a business that took him around the world, and my sort of earliest years were in Morocco. And although I'm English by birth and I've lived here all my adult life, the first thing I remember of England was actually coming to it, in a sense, as a foreigner, having grown up for just sort of 3 or 4 years, but, formative years abroad. So in a funny way, I sort of came to England looking at it from the outside, thinking, what a very cold, grey place.
And did you have siblings as well?
I've got one brother. He was the argumentative one, and I was the peaceful one when we were children. So it's always been a source of family amusement that the peaceful one has ended up in a career arguing, and the argumentative one joined the Foreign Office and became a diplomat. Right.
And how old were you when you came back to the UK?
I think I was 5 or 6. So we sort of came back to start going to proper school.
Right. And that was St. Paul's, as I remember.
That's right, yes. Actually, my parents were both brought up overseas too, and they hadn't quite twigged that schools like St. Paul's expect you to put your children down at birth. Well, they certainly did then. And they were a bit surprised when my parents turned up and said, well, we'd like our sons to come to St. Paul's. The school said, but you're not registered. So it took a certain amount of persuasion to get us in.
So, but obviously you got in, so that means your father was clearly a very persuasive man.
I think actually it was my mother.
How was your mother? Tell us a little bit about her.
Well, I have to say, fascinating life. They were both brought up in Shanghai. They've known each other since childhood. They're both 95. They're both alive and well. But Shanghai, I think, in the 1920s and 30s, was a fascinating, very exciting place. But of course, unfortunately, when the Second War broke out and Japan entered the war, they then spent the duration of the war in a prison camp. And when the war ended, having had no structured education, they both came to England, never having lived here, and both managed to get themselves into Oxford, which was astonishing, frankly. It would have been humiliating if my brother and I had not managed to get ourselves into Oxford, having had all the advantages of a paid education, when my parents were basically educated through the rest of the expat community in a prison camp.
Remarkable. Let's speak a little bit about school, St. Paul's. Were you boarding there?
No, it's largely a London day school. There is an element of boarding, but it's largely a day school. It is an English public school. It's very old. It was founded under the reign of Henry VIII. But it's very different from a lot of other English public schools because it has always been in central London. So it has always reflected the population of London. So it's much, much more diverse than most of the other public schools. And I think it also has a special place in the Jewish community because it was one of the very first public schools that allowed Jewish pupils. The founder, John College, was a humanist and religiously tolerant. So it's always had a very large contingent of Jewish boys. And as I say, equally a cross-section of the rest of whatever makes up the London community. So I felt very lucky to be at a fee-paying school. But after I had left, I realised how different it was from all the others because I then fetched up at university and met an awful lot of people who really hadn't met anybody who wasn't white, middle class.
Let me ask you about St. Paul's. That takes you through all the way to sixth form, does it?
Yeah, that's right.
And then you went to Oxford after that.
Reading history.
And which college were you at in Oxford?
I was at Magdalen, partly because it's just the most beautiful college, and partly because I wanted to read history because it's the one subject I loved, and because there was a chap called A.J.P. Taylor who was one of the history professors there.
I have his books behind me.
Well, I thought what a privilege it would be to be taught by him, which shows you how stupid I was, because he'd actually retired about 5 years before I applied. So I got up to Magdalen to find the entire history department was made up of medieval historians, which was not what I was interested in. So I had rooms in Magdalen and tutorials all over the rest of Oxford.
History, obviously, you say that was your interest at school, and that's why you read that at university. How the jump from there to law?
Because through a complete lack of planning, I realized once I'd finished at university that my contemporaries all seemed to have jobs. And I hadn't really thought that far ahead. And I remember very clearly ringing my parents at this stage were living in Belgium. And I remember very clearly, this was late 1970s, I was feeding 10-penny pieces into a public telephone box, trying to speak to my father in Brussels. And he came up with the immortal words, Jonathan, I think earning a salary is awfully overrated. Why don't you put it off? Why don't you put it off? Don't waste your time. Do something that will look useful, even if it isn't useful. So do a qualification while you're deciding what to do. So I literally started studying law because I didn't know what to do and I didn't want to waste my time. So I did a qualification and it sort of grew from there. Although to some extent, one of the other, why law at all, one of the aspects of history that I had always found interesting was English constitutional history, particularly during the 17th century, when the relationship between the crown, the nobility, the church, and what is still called the commons, everybody else, 99% of the population, those relations were being kind of sorted out in the way that you sort of recognize now through essentially parliamentary democracy. And I found that stage of English history fascinating. And I think the law contributed quite a lot to the evolution of what ultimately was a largely peaceful progression towards parliamentary democracy, apart from the Civil War, executing our king. Apart from those bits, the progress was, quite significantly contributed, if not, certainly not effected by lawyers and judges, but significantly contributed to. And I found that process and the relationship between the governed and the governor the most interesting. And I think that probably is why I leaned towards law rather than accountancy or something else.
Interesting. And in those days, how did one move from having a history degree to beginning to qualify as a lawyer?
Well, there was one provider in the whole of the United Kingdom who did what was then called a conversion course, which was the City University in the City of London. And it was completely ad hoc. It was very new. I think I was the second year that the course was run. It had no sort of formal premises of its own. Our lectures were entirely given by professors from Cambridge, Oxford, Bristol, and we used to have our lectures in a sort of chemistry lab. We would sit there with these sort of molecular structure models all the way down the sides of the rooms while we were listening to interesting points on contract law.
And during that time, obviously your discipline was history. You're now studying law. Are there very different skills in studying the two subjects, or different disciplines in studying the two subjects?
Academically, they are different. Because, studying law academically, to be frank, I did not find particularly interesting. I think it's a bit like the equivalent for a medical student having to learn, the human anatomy. Yeah, you've got to learn it because you can't become a doctor unless you know where all the organs and the blood vessels are and what their names are. And you've got to learn, again, for law, you have to learn your vocabulary. But merely studying law in the abstract, I don't find interesting. I think the stage at which the study of history and the study of law are comparable is when you're actually in practice as a lawyer, because at that stage, a bit like a historian, you have available to you a great mass of material and you have to assimilate it, synthesize it, and come up with a theory. whether that's a factual theory, a narrative to present to the court as to what did happen, or a theory, whether the material is all legal and you have to come up with a legal argument. Basically, both jobs, I think, involve being given a great big bundle of washing and having to clean it up, fold it neatly, and present it and make it look attractive.
And let me walk back just a little bit to ask you this: at that time when you finished your degree, you decided, well, let me get a qualification. Was there an option in the UK then of becoming a solicitor or a barrister?
Yeah, I could have gone either way. I suppose I preferred the idea of becoming a barrister for some very prosaic reasons. Training as a solicitor takes longer. You have to cover more ground. I had, one of my moonlighting activities had always, at school and at university, had always been in the theatre. I'd sort of half contemplated a career acting. So, people often say there is a similarity between actors and barristers. I mean, there is this much of a similarity in that you both have to feel comfortable standing up being looked at for speaking. I don't actually think there are particularly close similarities, but I suppose that is the aspect of the career that I enjoy most, is the interaction, the live interaction with an audience. It's a very small audience, but it's that interaction that I think truly
that drew you to the bar as opposed to them. Yeah. I think Ruslan wanted to jump in.
Hi, Jonathan. You did history at Varsity, similar with Jonathan Sumption as well, I think. What is it about historians then in the bar, you think?
I don't know. And as it happens, by pure coincidence, Jonathan Sumption was also at my college, as was Lord Denning.
He was a mathematician, I think.
Yeah, and Michael Beloff. And Dominic Grieve, who was our Attorney General for a while. Yes, I don't know what it is about history or Magdalen, but I think it may just be the two things that I mentioned. I mean, English history in particular is a story of a people sorting out the relations between the government and the people. That is essentially what English history is largely about. As I say, the study of history does have some significant sort of read across to the process of practicing law, in that you, as I say, you have available to you a huge body of information material, and the skill is to process that. And I think the single skill, I remember Lord Hoffman, who I got to know when I was much younger, and when he was still at the bar, and I asked him what he thought, the really important skill for a barrister was. And he said, an eye for relevance. And I think it's a very interesting answer. I mean, you can come up with any number of, one-line sound bites in answer to that kind of question. But it was a very, very interesting one, because I think it does capture, in a sense, what I was talking about. Because, if you're given a bundle of washing, you've got to choose exactly how to present it. There's no good, doing a bodge job and just trying to get the court interested in absolutely every sock, handkerchief, vest, shirt, because it's just not, it's not going to work like that. And, some of them are not going to be very neatly folded. So you've got to work out what is the point or points, and quite often just the point that really matters. And you've got to have the courage to shed an awful lot.
Let's now join the young Jonathan Krogh. Not that you're not young now, Jonathan. In 1980, he's just qualified, 1980-81, he's just qualified from the bar. He's just been called. What were your thoughts about your career ahead, and what was your route to the bar?
My thought at that stage, because there are no lawyers at all in my family, so I came into it from a position of complete ignorance. The two things that I thought about the bar was, first of all, because 80 or 90% of the English bar does crime and matrimonial work, I assumed that is what I would end up doing. And because I had met a judge, I sort of assumed that an old barrister must necessarily be a failed barrister, because nobody had asked him to become a judge. So I grew up assuming that becoming a judge was the whole point of the exercise, in a sense. That was the crowning glory for one's career. And I assumed that the path that I would be taking to get there would be, as I say, through a general common law practice, doing car accidents, maybe working one's way up to more serious crimes, and possibly, as I say, with some sort of matrimonial and personal injury thrown in. So that was my assumption. Of course, absolutely none of it has come to pass.
Tell us about why that is the case then.
Well, partly because I wasn't actually taken on in the chambers where I did my first pupillage.
Do they still exist?
Yeah. I still stick pins into my pupil master. Everything happens for a good reason. And they had taken on a couple of people the year before. As it happens, I think they didn't take anybody on in the year that I was doing my pupillage. And looking back, nearly 40 years later, I am heartily glad, because as it happens, I then I did a third six in a completely different set. Although I have to admit, at that stage, the other career that I didn't pursue, that I thought, I've always loved reading. I've loved books. I thought I'd actually go into publishing. That was the career I had. And I was offered a job with a publishing company. In the same week, I was offered the tenancy here at Stone Buildings, which is where I have been since 1982. And I had one of those sort of life-changing decisions to make as to whether to go with publishing or the bar. And I chose the bar, not because I loved it, because at that stage I can't say I did, but I chose it simply because I thought if I ended up really not enjoying the bar after a couple of years, I could flip into publishing much more easily than if I took up publishing and then decided I didn't like that and then tried stepping back into a super competitive profession like the bar. So I thought that it was the better choice in order to keep doors open. But as I say, I cannot pretend I loved it when I started. I think any career, you start with a huge amount of graft. There was a lot of very thankless donkey work. But I remember one gorgeous evening, actually, where I was sitting doing something I hated, which was drafting some contract of employment and articles of association and joint venture agreements. And my senior clerk came into the room. He knows me. He's been my senior clerk for my entire career. I do not know what I would do if he retired. We have a pact. We'll retire together. He came into my room knowing me inside out and could tell I was miserable. And he said, "What's the matter?" And I said, "Well, I hate drafting contracts and things." And he looked really surprised. He said, "Well, why didn't you tell me? Then we won't give you that sort of work." And I suddenly realized, oh my God, I'm self-employed. I can sort of choose, within certain limits, I can choose the sort of work I do. And it may sound bizarre that it hadn't really struck me, but that was the moment I realized I could actually, within certain constraints, choose my career. And things then started falling into place.
And those early years, who were the major influences in your practice?
It's very difficult to say whether anybody was really a major influence. I think, to a significant extent, when one is young, although one probably would not wish to acknowledge it at the time, I think one's own parents are still the major influence. And I think that one thing that I have always carried with me is a sort of a sense of intellectual independence. I was brought up in, I suppose, in one sense, a very, very conventional way. I was sent to a public school and then I went to Oxford. My parents were both at Oxford. But I think that is a very superficial element. I think what really matters in anybody's makeup is their attitude, their intellectual and, moral attitudes. And I think the one thing that my parents both had was a sort of a sense of combined intellectual curiosity with an independence of thought. And I think that's very, very helpful in law, because I think if you are a sort of a cradle lawyer, if you've done it from the time you left school, you kind of regard the law as this sort of great edifice that you sort of worship at. Whereas if you come at it as an outsider, and I still, in a way, I still think of myself as an outsider to the law, because I didn't do it at university 40 years ago. But if you come at it as an outsider, you kind of recognize it for what it is, which it's just a tool to achieve results for your clients. It's not a god to be worshipped. And I think that attitude, that sort of pragmatism and that independence of thought, I suspect I got, as I say, from my parents rather than from any lawyer.
But in terms of lawyers that you did work with in those young years, would you point to anyone and think, yes, I think he shaped my career or he shaped my thinking about practice or about the law?
It may sound a little mean to say this, but I probably find I learn more from watching people do things badly rather than admiring people who do things well. I think I say this in terms also of self-criticism. I learn as much from being brutal with myself about admitting a mistake as I do from sitting open-mouthed with admiration at somebody else doing a fantastically good job. I think there's a combination of things. You've always got to respect your opponent, whoever they are. Because even if somebody is making a slightly ham-fisted job of something, they can come up with a point that can win the case. So I think it's incredibly dangerous not to have respect for anybody who is against you, because they can just win a case, blindsiding you. They can be bumbling along, making a terrible presentation in one sense, but they can actually get the point that wins. So I think it's very dangerous to fall into the trap of admiring somebody because of their apparent fluency or because of the intellectual beauty of the argument, if in fact it's the argument that isn't going to win, or it looks incredibly beautiful but it's got a crack right through the middle. So funnily enough, as I say, it sounds a little bit grudging or ungracious to say, but I think one probably learns as much from watching mistakes and admitting one's own mistakes as one does from seeing something well done.
Well done. What about scholarship? I mean that's sort of the thinking and the presentation, perhaps. But in terms of just pure legal scholarship, did you have anyone in your early years that was able to guide you in terms of practical legal scholarship for barristers, or is that something you just picked up on your own?
No, not really. I think it is something you pick up. The one thing that it's difficult to convey one thing to anyone who isn't really in my set of chambers, which is that we are a very, very small unit. When I joined my chambers, I was the 15th barrister in the chambers. I mean, in the last 30 whatever years, it's now grown to about 35 or 36 barristers, something like that. It's a very small working unit. And, that 35, 36 people, there's an age range from sort of late 60s down to sort of late 20s. So there's a hugely wide age range with not very many people. So we all have very different experiences at each stage. There is a very kind of open door policy within chambers. There's a huge amount of interaction. People pick each other's brains. People walk in and out of each other's rooms. They discuss things. We have a chambers tea every day. We've been having virtual chambers teas during lockdown on Zoom. It's a very open, collaborative and sort of mutually supportive environment to work in. I mean, we're all spectacularly competitive if we're against each other in a case. Absolutely no quarter is given. But the general sort of working atmosphere is incredibly collaborative. So when I was young, everybody above me in chambers was clearly better and more experienced than I was. So, I would learn one thing from one person and another from another. I never had, one sort of idol who I admired throughout. Partly, I think, because the bar requires dozens of different skills. I mean, the skill you need to win a case in the Supreme Court is entirely different from the skill you need to cross-examine a dishonest witness. And the skill that lends itself to cross-examining a dishonest witness is very different from the skill you need to win the confidence of a troubled, anxious client. You need to have a lot of different qualities in order to succeed. And frankly, some people are much better at one than the other. So I don't think there's a sort of single model that makes you the perfect barrister, so to speak, because you need different barristers for different jobs or different qualities for different aspects of the job.
Now, you spoke earlier about suddenly realizing you're self-employed and you could choose the kind of work you wanted to do. So between 81 and I think it's 1994, you're in Stoughton Buildings. What sort of work did you choose to do during that time?
I was just incredibly lucky. I got an extraordinary variety of work. I had a good line in heavy metal groups, not entirely sure why, but the music industry generates a certain amount of money, and wherever there is money, I'm afraid to say there tends to be disputes. So I did quite a lot of work in the sort of music and media, and through that I started working for people in sort of PR companies. I did a certain amount of sort of regulatory stuff. A lot of my clients were in trouble, so I spent quite a lot of my time appearing against regulators and against government departments, and that I indirectly then led to the sort of next stage of my career, which was when the government appointed me, slightly to my surprise, as first Treasury Counsel, which is a position that I suspect only the English could have invented, because the idea is that the Attorney General is, in constitutional terms, the legal advisor to the government. The Attorney General is always in government. He is a government appointee, and so he will almost always be a career politician. So he'll be a career politician with a legal qualification, but he won't be a practicing lawyer. So a convention developed, I think, sometime in the late 18th century, where the Attorney General would get his colleagues in government to say, well, we got this problem. What's the legal answer? And the Attorney General would have a sort of permanently retained ghostwriter, so to speak, at the bar. There would be a barrister who was permanently available to advise the government. And that is the position of what is known as the Treasury Devil. Deviling in the English bar is an expression that's used to describe a junior barrister basically ghostwriting work for a more senior one. And the Treasury Devil is the position where, because the Treasury has essentially a monopoly on legal advice, the Treasury solicitor is, in fact, not just the solicitor to HM Treasury, but to the whole government. It's just the title for the head of the government legal department. And the Treasury Devil, which is what I became, is the person who ghostwrites the Attorney General's advice to government. So for 9 years, I was still technically self-employed, but I only had one client, which was the government. And it would involve advising any government department. So I did cases about which I knew absolutely nothing before being instructed. I would generally get a more junior specialist, but I would do a pensions case, a tax case, an employment case, an immigration case, never having done any of those things before in my life. And by definition, I was doing the ones that really mattered to government, because they wouldn't otherwise have come to the Treasury Devil to deal with them. So, so as I say, it is the most extraordinary idea to have one barrister as your principal point of representation at the bar, who will almost always be appearing in cases of consequence against other barristers who actually know what they're talking about.
And do you actually remain in chambers while you're Treasury Devil and Treasury Counsel?
Yeah, physically, I mean, nothing changed. Yes, I had the same room in the same building. I just had, one says, one client. I mean, constitutionally, I had one client, but literally one day I would have the chief officer of the fire department, and the next day I'd have the Ministry of Defence. And quite a lot of the time, and I have to say, this is one aspect which I found utterly fascinating, because you obviously have to be security cleared up to here. I advised and represented the security services. So I had a huge safe installed in my room, and I would advise MI5 and MI6 and GCHQ. And I have to say that those aspects of it, one would never, ever otherwise even know were going on, or least of all know anything about. So, I mean, the variety was astonishing. To say that one had one client is completely misleading, because it was it's an explosion of different kinds of work across my desk, and it was a huge privilege to do.
Did you ever for a moment think, nope, I don't want to do that, I want to just stay at the commercial bar? Did you ever have any doubts about taking on that that role?
Absolutely. I mean, I was in a state of heightened anxiety when I was asked to do it, because now one has to apply for these. I was sort of literally the last of the generation where you got a phone call from the Attorney General. I was in my late 30s. I think I put in an application to become a QC because I saw my way forward as becoming a commercial QC. And the Attorney General rang up and said, would you like to withdraw your application for Silk? And I said, no, thank you. Why? And he explains that the convention was that because the Attorney General is always a QC, it would be undignified if he was having a ghostwriter who was also a QC. So the convention always was that the Treasury Devil wasn't a QC. And they wanted me to take the job on, so they wanted me to withdraw my application to become a QC. And I have to say, I mean, if it had been a job that you had to apply for, I would never have done it, because I would never have thought in a million years I was the sort of person they wanted. But Lord Faulkner, Charlie Faulkner, was then the Solicitor General, and I knew him just through the bar, and he had just been appointed. This was 1998, so the first Tony Blair administration. And I knew Charlie Faulkner quite well, and he asked me round to try and persuade me to take the job over a weekend. And I was flattered, obviously. I mean, it's a huge privilege, but I was completely blindsided because it was absolutely not the career path that I had in mind for myself. So I said to him, well, look, okay, this is fascinating, but, why me? Because my predecessor had been a sort of more of a kind of a black letter lawyer, a proper advisory man. And my practice was very litigation based. And Charlie Faulkner's answer was fascinating, and it probably is what persuaded me to do it. He said that the Blair administration, when it was first elected, had a huge majority in the Commons. And he said that if you look back through law reports, at some odd level, no doubt entirely subconsciously, judges are more interventionist at a time when the government has a huge majority. Because if there is no opposition, so to speak, in Parliament, at some level, the courts feel they've got to kind of step up to the plate and make sure that the executive government is not sort of exceeding the bounds of its proper powers and so on. And so he said that in judicial review of government action, the Blair administration reckoned they needed a litigator. They didn't need a black letter lawyer. They wanted somebody who could look after himself in court. And that was why they had asked me to do it. And I thought, oh, well, that is interesting, because they clearly thought it through. It was in the honeymoon period when Saint Blair was just the idol of the press. But they had thought it through, and they realised they were going to get a bumpy ride in the courts, and it was not going to last. The honeymoon was not going to last indefinitely. It certainly wasn't going to spread across to the courts. So I thought, well, that's super interesting. Let me think about it. And Charlie said, yes, fine. Tell me on Monday. And I said, oh, I wanted a little longer than that to think about it. And he said, well, look, it's going to be a difficult decision whether I give you 2 weeks or 2 days. So I'm going to give you 2 days. And I just said yes. I thought, it's so unusual. There are hundreds of QCs. There is only one Treasury Devil. To be asked to do it, it just seemed idiotic not to say yes.
And you did that for 94 to 2006, is that right?
Yeah, it was like 2 stages. 94 to 98, I was what's called Treasury Counsel, which is a sort of slightly lower rung. 98 to 2006, I was first Treasury Counsel.
That's when you were first Treasury Counsel. Okay. And did you take Silk after you stopped being Treasury Counsel? That's the convention, is it?
No, the convention is that when you've done an indeterminate number of years as Treasury Counsel, they pat you on the back and say, thank you very much, have a knighthood, you're now High Court Judge. And that was the point at which my career sort of took another slightly unexpected turn. And it was the point at which I started again. It was a bit like when my senior clerk walked in and said, why you didn't say gloomy? It was the sort of second wake-up call I had, because I took the job as Treasury Devil, partly because I was still living in the belief that becoming a judge was the point of the whole exercise. And I knew that all my predecessors who had become Treasury Counsel had gone on to become a High Court judge, and quite a lot of them had gone on to the Court of Appeal and the House of Lords. And I suppose I took the job partly because I thought, well, that is the career path that I am expecting to pursue. And, in a sense, it makes sense to follow that path. But after sort of 7 or 8 years as first Treasury Counsel, it got to the point where I was being sounded out as to whether I wanted a tap on the shoulder. And it was the first time I really started thinking, well, actually, do I want this? I'd been sort of living almost with a habit of thought that becoming a judge is what was going to happen. But I suppose I'd never really sat down and asked myself if I positively wanted it. And when I started thinking about it, I realised I had some unfinished business at the bar, because although the Treasury job had been absolutely fascinating, I had spent 9 years without cross-examining a single witness. I mean, all the government work is points of law. So, I mean, absolutely fascinating and hugely varied points of law, but it's all very statesmanlike. And as I say, it's not kind of litigation in the sense of a pub brawl. And because I hadn't chosen it, and I had, been pulled off track, so to speak, I'd had to withdraw my application for a silk. I felt there was a career at the bar I still hadn't had. And I also started thinking, well, being a judge is interesting, but it's very passive. You sit and you listen, and it's obviously interesting, and it's very nice to be able to say what the answer is rather than merely arguing and having no control over the answer, which is what a barrister does. But I just suddenly realised actually what I liked about the bar was missing on the bench, because what I like is being presented with a bundle of washing. And I like working out, which bits to fold and how to present them. And I like, the engagement of working with people, of trying to persuade, and literally sitting and listening, which is what judges do. I began to realise it was not what I wanted as a full-time career. And there were also other entirely prosaic things. I mean, my wife has had a totally different career. She was in fashion PR, and she had founded her own company and sold it. And she had got, at about that stage, she had got to a point where she felt, in a sense, she had nothing more to prove in her career. And we were thinking about having a few more children, and we did a bit of maths and bringing up 4 children on a judge's salary. Doesn't leave an awful lot left over to buy a loaf of bread. So I think, for a combination of reasons, I went back to the Attorney General and said, look, I know what all my predecessors have done, but do you mind if I don't? Do you mind if I go back into private practice? And I think they were a bit horrified at the idea, because it was novel. Novelty is not a sort of favourite thing, either in government or the law. And I think also there had been, I think, one previous example where this had happened, but it had not been a success, because the chap who had been first Treasury Counsel became a QC, stayed at the bar, but hogged all the really interesting government work. So his replacement as first Treasury Counsel was left with crumbs and cast-offs. And I could absolutely see, well, that is absolutely not why I wanted to go back into private practice. I wasn't going back into private practice to get the letters QC after my name, but carrying on doing exactly the same job. So I sort of made a pact with them that I would absolutely walk away from government work and I would carve my own career with private clients. And I think that reassured them. So that's what's happened.
Any regrets at all?
No. Absolutely not. I mean, I feel idiotically lucky to have had essentially 3 careers at the bar. As a junior, I had my heavy metal bands and my colourful entrepreneurs. As Treasury Counsel, completely different, very largely public law, at a time, which could never be replicated, because, I was appointed just after the Human Rights Act was enacted. So the whole English court system was kind of making it up as we went along, and to have been there through that period was fantastic. And then to come out the other side and now to have had a 3rd career essentially as a QC, where because of the variety of work I did with the government, I think I'm unclassifiable. People often, if I meet somebody, and they say, oh, what kind of law do you do? I still haven't quite worked out a decent answer to that, because according to the sort of legal director, I'm a specialist in 10 different areas, which has got to be a contradiction in terms. I mean, the one thing I most enjoy, having got through it all to this point, is appellate work, because I've now been back in private practice since 2006. So I've had 14 years of trials and witnesses and far more tactical litigation than one had in the sort of the public law cases. But actually what I really enjoy now, and I suppose this is more similar to what I was doing as Treasury Counsel, is just being presented with a problem, usually something that has failed in the court below, and the client wants to take it on appeal. And whether it's a case about patent law or banking or whatever, doesn't really matter, because it's just a self-contained problem, and one has to work out a way of identifying the winning point.
Well, let's now jump into perhaps a fourth and fifth career that you've had at the bar as well. The first is sitting as Deputy High Court Judge. You also sit as a Court of Appeal Judge in Jersey, I understand. And also you're the Attorney General to the Prince of Wales. So on that fourth career as a judge, just very quickly, if you could tell us, do you think that's made you a better advocate sitting as a Deputy Judge?
I very much hope so. I certainly believe it. I think if you sit facing the other way around in court, looking at the advocates presenting, you suddenly realise what matters to a judge and what helps a judge and what doesn't. And I think certainly when one starts out, one may have the feeling that fighting your corner is the thing that wins the confidence of your client. And I think some people, some barristers, retain a combative approach to their job. And if you do sit as a judge, you realise that aggression, it just doesn't help. And worse than that, it's unpleasant, frankly. I mean, the only real justification for having professional lawyers at all is to ensure that what might otherwise be a thoroughly unpleasant squabble, which is what would happen if you had lay clients appearing against each other, is conducted in a civilized way. So I think, our main function, apart from being, good and honest, our main function is to conduct litigation in a civilized way. I mean, that absolutely is why there are professional lawyers, as far as I can see.
And as Attorney General, the fifth career to the Prince of Wales, what does that involve?
Well, that is a real cherry on top, I have to say. It's a fascinating and, again, an enormous privilege. Part of it is ceremonial. Turns up at Buckingham Palace Royal Garden parties and presents tenants of the Duchy of Cornwall to the royal family. Part of it, the main bit of it, is almost like being a non-executive director of a large property company, really. The Duchy of Cornwall is the estate that was conferred on the Black Prince by Edward III in the early part of the 14th century in order to create an inheritance for the heir to the throne. And the Attorney General to the Prince of Wales is part of what's called the Prince's Counsel, which is what runs the Duchy of Cornwall. And it is, I mean, the titles are charmingly medieval because they date back to the 14th century. So we have the Lord Warden of the Stannaries, who is effectively the chairman of the council. We have the Receiver General, who is the sort of the finance minister. And we have the Keeper of the Records, who is effectively the sort of the CEO. And so we have what are, to all intents and purposes, board meetings at which I am a non-executive director. The real work is done by full-time employees and committees, and they report up to the board. But the third aspect of it, apart from the ceremonial and the non-executive, the third aspect of it is genuinely legal. So issues that affect the duchy come to me if they matter. And I'm possibly one of the most sued litigious people in the country, in the sense that it's beneath the dignity of the Prince of Wales to bring proceedings in his own name. So if any tenant hasn't paid their rent, proceedings are issued in the name of the Attorney General.
Make you a very popular man then, Jonathan. Before we jump into the general areas, and we'll deal with that hopefully fairly quickly, let me just ask you about practicing in other jurisdictions, because I know, looking at your CV, that you practice in the Caribbean. What I wanted to ask was, Is there a difference, an appreciable difference in the way you practice in those jurisdictions compared to practicing in the UK?
No, I don't think there is. I think that some people treat overseas jurisdictions in a different way, and I don't. I think that the skills that are required and the approach that you take are absolutely identical. I mean, the rules may not be identical, and the tribunal will not be identical, because it won't be, on the whole, if one is doing a High Court case in London, because, there is so much more litigation. You will be appearing in front of a judge who is extremely familiar with a particular area of the law. Whereas in smaller jurisdictions, the judges have to be much more generalist. So the tribunal will be a less specialist tribunal. But that, to me, doesn't produce a different approach from the advocate. I mean, essentially, it's exactly the same task. You are given a set of rules, whatever the local law is. You're given the bundle of washing, the set of facts, and you're given a decision maker. And your job is to work out how to present something attractive to that person and persuade that person. So myself, I don't see any significant difference at all.
Right. Okay, let's get into a little bit more a sort of generalized area about practice and your practice in particular. First off, is there any particular aspect of practice that you would say, yeah, that's what I enjoy the most?
Winning.
Don't we all?
I think being a bad loser is quite a useful quality, actually.
Yes, it is.
I think you've got to go into court wanting to win. I mean, not voraciously, aggressively wanting to win, but you've got to be driven. You've got to want it every time, because the moment you go off the boil, the judge notices, your client notices, the solicitor notices, you've got to stay hungry. That's not an entirely helpful answer to your question. If there is an area of the law that I find interesting, it is probably public law cases which involve, the most interesting ones I have done have involved, because most legal disputes are sort of bilateral, you have claimant defendant. The two cases really that I found most interesting are ones where there's a sort of triangular relationship, and that both of them involved the state, parents, and children. And so the two cases that I will probably take with me to my grave as being, in a sense, my favourite, if you can use that word, involved, one of them was the lawfulness of prohibiting certain forms of religious dress at school. And the other one involved the abolition of corporal punishment in private schools. So corporal punishment in state schools had been abandoned long since. But there was a strange kind of cohort made up of surprisingly different people. There was some sort of Jewish, but also some low church Christian people who took the bit in the Old Testament saying, if you spare the rod, you spoil the child. They took that as an explicit exhortation that children occasionally need to be thumped in order to instill the fear of God into them. And so there were some parents who chose schools because those schools still administered corporal punishment, and the government abolished that. And I found that kind of dispute absolutely fascinating, because that really does crystallize the sort of the aspect of the law that I find most intriguing, because it involves not just the relationship between the governed and the governor, it's the government trying to take a decision, but that decision is affecting two constituents. It's affecting the parents, because the parents have their right to bring their own children up according to their own understanding of their own religious beliefs. So that has to be respected. But the state also owes responsibility to the children. Is it right that the state should be allowing children who are not themselves making the choice to go to those schools to be beaten? And I found that sort of, as I say, that triangular relationship between state, parent, and child, I found the most fascinating.
Okay. People now, the opponent that you respect the most, and the judge who challenged you the most.
I can't answer the first. In a sense, the answer, because, well, really for two reasons. One, as I say, what you admire in cross-examination may be one thing, and one person may excel at that. And what you admire in difficult interlocutory application where it's just a matter of almost attrition, where you just got to grind the judge down to accept not because it's good or right, but simply because you're gunning away, again, is very different from what you need to win in the Supreme Court on a point of law. So it's very difficult. As I say, in terms of learning things from other people, I learn probably more from watching people's mistakes than I do from admiring somebody else. And I think that one of the risks, actually, perversely, one of the risks at the bar is trying to learn from other people doing it well, in the sense that, well, I think one of the skills one needs as a barrister is to find your own voice. I think you can sometimes see people who are clearly imitating something that they've seen somebody else do and thought, oh, that looks rather good, I'll try that. And it looks phony. If somebody is not being themselves in court, it just looks artificial. So I think admiring somebody else's performance, delivery, whatever it is actually strangely a dangerous thing to do, because it may lead you to lose your own voice. The judge who challenges me most, well, again, it's difficult to pick out one, although oddly enough, Lord Justice Stephen Sedley, for some reason, just had a way of asking a question which was inevitably absolutely relevant and really, really difficult to answer. I mean, super clever. And I remember saying to him once, actually, because there was one particularly hilarious moment. So I always didn't dread appearing in front of him, but I always knew, I had to be absolutely up to speed. And I remember there's one hearing in the Court of Appeal where he just came in with a question. And 99% of the time at the bar, you can kind of think of something to say while your brain is whirring and you're actually coming up with the real answer. You can think of some sort of filler to keep you going and buy you about 15 seconds while your junior passes you a note or your brain engages. Stephen Sedley asked me a question and I couldn't even think of a time filler. It was one of those absolutely sort of awful moments. And it was hilarious. What was hilarious was that Lord Justice Lords was on the same tribunal, three of them up there. So Sedley on one side, Lords on the other, and I can't remember who in the middle. And Lord, Sedley asked this absolute humdinger of a question to which I had no idea what the answer might be. And Lords just leant forward across the chap in the middle and said, but surely the answer to that is this. And he just came up with this absolutely perfect answer. I hadn't said a word. I was suddenly dug out of this appalling hole. I told this story. I met Stephen Sedley shortly afterwards, and I told him that, and he was sort of both delighted and horrified, because he was an incredibly nice, kind man, and he was actually sort of genuinely mortified that I should regard him as being terrifying on the bench, because it clearly wasn't his intention at all. But it was just, I think, the sheer intellect of the man that was intimidating.
Okay, next question. Quick answer to this one. What is the most important quality in an advocate?
Well, I've already given you Lenny Hoffman's answer, so mine is just going to be integrity.
Thought it would be.
Yes. Going back on the cases that you said was that you, I suppose, remember the most. I was reading one of your cases, actually, MISL and Raven, the Madoff case. And I think you represented Mrs. Cohn, one of the defendants, and you got her off. At the end of the day, Justice Popperwell said, basically, this was one of the most, I suppose, unfair civil suits. Because, and I remember this because I used one of these cases unsuccessfully, I may add, in defending a client who got a Mareva injunction against her. And because there was a lot of cases, and basically there were briefings essentially on Mrs. Cohn's and all the defendants because of the Madoff name. I think PR companies were appointed, so on and so forth. And basically they were hung out to dry even before the trial went on. Do you find defending this case particularly disconcerting or difficult, considering, with due respect, what MISL basically did? I mean, the pressure you must have faced there.
Actually, and that's a fascinating question. I'm not going to give you a short answer.
A long question too, actually. Sorry.
Yeah, no, it's a really interesting one. Yes, I found that case possibly one of the most stressful I have ever done. Not because it was factually or legally more complicated than any other, but it was fantastically highly charged in the sense that the claim had been brought by the liquidators. And I think, the claim was driven from America rather than from London. And I think the judge's comments about how it had been conducted resonate with what I was saying about what you learn as a judge, sitting as a judge, about how to conduct a case as an advocate. Because I think one thing, and this is not what wins or loses cases, but it certainly affects the atmosphere of a case. The liquidator had issued a press release describing my client as Bernard Madoff's criminal soulmate, whose greed and dishonesty equaled his own, before issuing the proceedings. He hadn't even served them on her. She found out about the proceedings by reading her being described in those terms in the newspapers before the writ had even been served. And I think that level of presumption and aggression on the part of a claimant is spectacularly counterproductive, because you have set the bar so high for yourself by pitching it in that way, that if you fall anything short of that, the court just doesn't want to go with you. So personally, I think that was a shocking error of judgment on the part of the liquidator to adopt that approach. But I mean, the reason, one reason why the case was extremely stressful is that Mrs. Conn herself was of a Polish Jewish family. And she was of that generation where she was the only survivor from a family that had been wiped out in the Holocaust. And that kind of experience has obviously a kind of impact that none of us could ever understand. But I think one of the things that it did for Mrs. Conn was that it made her have this overwhelmingly strong sense of preservation for her family. So everything she earned, she immediately passed down into trusts for the sake of her children, her grandchildren, in fact, she had great-grandchildren. The claim that was brought against her was a tracing claim, which would have meant not only that she lost all her money, but essentially, if it succeeded as drafted, it would have wiped out her entire family financially. So everything that she had fought for to acquire and preserve, to keep the clan going, would have been taken away. And obviously, one wants to win every case, as I say. You've got to go into a case hungry. But if you've got a corporate client, you know that the corporation is going to survive. And of course, it would rather win. Of course, you would rather win. But that extra layer of anxiety, I suppose, because it was a very, very personal claim with very human consequences, made it spectacularly stressful, even by comparison with, frankly, anything else I think I've ever done. And so, yes, I was extremely glad and proud. And I have to say, she has remained hugely grateful. She's a lovely lady.
Well, if I can follow that up, Jonathan, with the issue of stress, what's your release valve when you've got a case like that?
I don't have one, actually, although part of the answer sort of leads into what you were about to ask about a day in the life of. I get up at 6 in the morning and I don't stick around at home. I cycle to work, which is about 5 miles each way. I almost never work at home. I like having the segregation between working at work and being at home. And I suppose, in a sense, I don't have a release valve, but I have that the moment, the process of disengagement at the cycling for half an hour. It just disengages, and being at home and not having any work at home means that work is segregated. So I'm quite good simply at shutting the door at work. And as I say, because my wife had a career wholly unconnected with the law, even if I wanted to, I sort of couldn't bring home the baggage of the kind of stuff that I do because it's not her career. So I think, frankly, disengagement from work and family is what keeps one sane.
And after you get to chambers, you ride in, you get in very early, 7:30, I understand. And then how does your day move from there?
So it very much depends. What I try doing is getting rid of all the sort of rubbishy emails in the first sort of half hour, because there's particularly if there are cases in different jurisdictions, you've got people working on different time zones. So I always try and leave about sort of half an hour or something, very first thing, to get rid of, just to deal with all the sort of the clutter of emails. And then, to be honest, I do quite a long day, I suppose. I mean, I leave the house about 6:15, 6:20. I'm normally in work actually just before 7, and I normally leave at about 7. I'm here so roughly 12 hours most days. I try not to work weekends because I just think, you've got to have a life, and our children are not particularly impressed by work at weekends. And I think that, that is good grounding. I think there are... Can I tell one anecdote? Are we running out of time?
Please do. Yes. No. As long as you're not, we're not.
I had a lovely experience about 5 years ago where a solicitor rang me up and asked me to do a big commercial case for a Ukrainian client. And I was getting to the stage where I felt I'd had enough of long trials. I said to him, look, it's very nice of you to ask, but I'm not really looking to do long trials anymore. And the solicitor said, okay, fine, but can I bring him round to see you? Because I think you'll like him, and he'd like, we would like you to do the case. So I said, well, I can't stop you bringing him round. Yes. So he came round, and he was an absolutely charming man, and chatted, and they went away. And the solicitor rang up afterwards and said, well, what did you think? And I said, well, he's absolutely delightful. He's a charming man. I'm sure he has been wronged by the other side, but I'm not going to do a long trial. And so he said, well, I completely understand. And then a week later, we had exactly the same conversation. And then about a week later, he brought him back again. And it went on and on and on and on. And eventually, he just ground me down. I said, oh, all right, I'll do it. But funny enough, I discovered afterwards that the one reason, rather charmingly, why this particular lay client was so keen that I should take it on. I mean, presumably he had been told something nice about me professionally. But the charming detail was that early on, I think the solicitor had written to me, one of those messages, the subtext of which was, the client is quite rich, there will be an upside to doing the case. And I had written back an email saying, I completely understand, thank you very much, and it's very flattering to be asked. But there are a large number of extremely rich divorced barristers, and I don't want to add to their number. Because I think one of the problems of long trials is you completely lose your private life, and you cannot avoid working all weekends for quite long periods of time. And it is a terrible intrusion. And apparently the solicitor was so sort of amused by that, he actually showed that email to the lay client. And when I finally did take the case on, and as it turned out, it went very, very well. The client loved us. We stormed to victory. When we were having our sort of, celebration dinner afterwards, the lay client told me this anecdote. He said, that was the point, Jonathan, where I really knew I wanted you to do the case. Which is a very nice reflection on him, because he himself is a happily married man, and he understands the importance of keeping a well-balanced life.
Brilliant story. Let me now just ask you a little bit more about sort of the practical aspects of how you approach it, more mechanical aspects of how you approach some of the stuff that you do. And let me start with, and this is not mechanical, of course, with presentation and language. And the reason I want to start with this is because Singularis, that case, begins with these words. Jonathan Crowe QC boldly asserted at the outset of his submissions that this case is in fact bristling with simplicity. And I think she closed the judgment. Lady Hale closed the judgment with those words as well. So what I wanted to ask these words stand out and they will carry the test of time. Do you sit down and really think about the language that you intend to use?
Yes, absolutely. I also plan an enormous amount that I, in the end, don't use. So it was almost by accident that I did actually say that, in the sense that it was certainly something that I had in mind to say, but I wanted to see how the first 5 minutes went before I said that. because we were the respondent in that case. So the court had just heard my opponent on his feet for, I think, the better part of a day. And there were a lot of issues that he had been addressing, and it sounded complex. And essentially, the main body of our response was, actually, if you hold it up to the light, it is really, really simple. But you can't, I think this is one of the most fascinating skills as an advocate, and it's true of written advocacy as well as oral advocacy. What you obviously want to do is to get the judge on your side. It's quite nice if you get the judge, for example, indignant with how the other side has behaved. It's quite nice if you get the judge to think that the other side has overcomplicated their argument and that there is a very simple way of resolving it. But what you cannot do as an advocate is to make a judge feel indignant or cross with the other side by telling the judge to be cross or indignant with the other side. And you can't persuade a judge that the case is very simple by simply saying, this case is really simple. What you've got to do is demonstrate. Show, don't tell, as somebody once said. You've got to demonstrate that it is simple by setting out the building blocks and say, look, if you just look at this issue, then that issue, then that issue, it gives you the answer. So, yes, I did use those words, and I'm glad I did, because it obviously struck a chord. But I didn't start with them, because if it's the very first thing you say, the court is quite likely to bristle. So I spent about 5 or 10 minutes. It wasn't, she said it, I opened the case. Yes, I said it quite early on, but it absolutely wasn't my opening line, because I think that
No, you did the headlines first, I think. Yeah.
You need to build the building blocks first. And if you come up with something like that, it sounds a bit like a sort of glib soundbite rather than a conclusion to the structure that you put in place.
Right. That's really interesting. Can I just ask, just in terms of presentation, and I don't know whether you can have an answer to this, but you have a block of time that you spend preparing for a case. How much of that, in terms of percentage, do you spend on thinking about how to present it, imagining yourself standing there?
Almost all of it. I think I am probably a neurotic over-preparer, because I write and rewrite my notes for any case, because it's got to flow, and you've got to, there are so many things. Obviously, cases tend to be about one or two things. That's ultimately what you've got to address. But there are so many sort of micro choices about the sequence in which you deal with things, whether you go to, case law before statute before case law, arguments of principle, the structure of, the sequence in which you take the main points, what not to say is almost as important as what to say. One of the things that it took me quite a long time to realize is that you can win a case without having any answer to some of your opponent's points. You don't have, I think when you start, I certainly felt I just had to deal with everything. My opponent's made 15 points, I've got to answer all 15 and come up with a convincing answer to all 15. You don't, actually. Because if 14 of those points look persuasive but actually don't get him home, you need to answer the 15th point. As I say, having the courage not to deal with things because they don't matter, and having the courage to shed a rubbishy argument and concentrate on the good one is, I think, what comes with experience. So, yes, I spend a huge amount of my time, and I prepare very, very detailed notes, and I go over and over and over them. And sometimes I literally turn my notes upside down. I just suddenly, I have gone through it, and I do essentially sort of imagine myself in court, and I go through it, and I think, no, that is just not going to work. I've got to do it the other way around. I've got to deal with this first, and then drop that and move that here. So I spent a huge amount of my time writing and rewriting my notes. And sometimes I make decisions on my feet. There are times when you can just feel that the court is anxious about something you're going to come to much, much later. But if you leave it to where you had it in your structure, they will have been listening to a whole load of other stuff, still worrying and not really listening, because that's the thing they're anxious about. So one of the many, many skills is knowing when to take something out of sequence in order to put them at their ease and then get back onto your track. But all these things. One of the questions I think you ask is, what's the most important quality for an advocate? And I was really struggling before this interview to sort of come up with a sensible answer to that, because I think almost anything that you say in answer to that has a sort of a counterpoint. Because, one thing that you have to be as an advocate is responsive to your audience. There's no point in turning up in court with an absolutely rigid structure to your argument if the court is clearly, not interested in that point, but really worried about that one. You've got to deal with it. But you can't be so flexible that you lose your structure. And I remember some years ago, there was a fascinating case where, again, it was in my days as Treasury Counsel, when I was in the Supreme Court, as usual, I was against somebody who was a real specialist in this particular area of the law, and I was complete newbie, never having done it myself at all. He stood up to present his argument, and he'd got about 10 seconds in, and one of the 5 judges asked a question. And he gave, because he knew this area of the law so well, he gave a really long, detailed answer. And it was fascinating. And it prompted one of the other judges to ask another question, and he answered that, which prompted somebody else to ask something else. And he gave these long, full, incredibly learned answers. And we got to 1 o'clock. And I saw him look down at his notes, and he realized he was on page 1. He hadn't developed his argument at all. He'd been on his feet answering questions, but with no control over where his presentation was going. And he lost. And he just had not developed his case. So, as I say, what qualities do you need as an advocate? You need to be flexible. You need to respond, but you need to be disciplined. You need to have a structure and stick to it. So for any sort of quality that you can identify, you need to be able to balance it with its opposite, almost. You need to be hungry. You need to want to win. But you don't need to want to win so aggressively and hungrily and angrily that you're going to piss everybody off. So, the answer, I suppose, what quality do you need? You need balance.
Yeah, interesting one. Cross-examination. Do you prepare in the same way? Do you just go through your notes and again, getting your sequencing right? And do you write down every question, or do you do it in bullet form? What's your style?
I don't write the wording of each question. I know some people literally have a script, with Mr. So-and-so, comma, please turn to page something, comma, blah. I think that that kills any kind of oral presentation. If you're literally reading out, your head is down, and it just doesn't work. Whether it's advocacy or cross-examination, you've got to engage. You've got to look at the person. But yes, I do have incredibly detailed notes. Yes, I have plotted every single document I'm going to go to, and I will have. I'm afraid I'm sufficiently old school. I still work from paper bundles, and I have detailed notes on the pages. I've got a very visual memory. So when I think of a document, I know what my points are because I can remember having scribbled on that bit of the page. So yes, I'm super prepared on cross-examination. And funnily enough, I probably spend less time rearranging the cross-examination than I do legal argument. Legal argument is much more kind of fluid. Cross-examination, because there is the structure is almost always dictated by the chronology. You go to things in the sequence in which they happened. And it is almost always the case that the truth comes out once you have established the sequence in which things happen. In that sense, it's quite a mundane process, slightly laborious because you've got to piece everything together. But I find it less difficult to structure cross-examination. But it is super time consuming, because you have got to work out exactly how you want to maneuver somebody into an awkward position. And again, the only other thing I've learned, I used to think, as an outsider, that the idea of cross-examination was to get the witness to admit they were telling a lie, which of course never happens, literally possibly once in a lifetime. But what you need to do is just to get the witness to look stupid. They're never going to say, yeah, he's a fair cop.
Fantastic. Well, Jonathan, that has been a really riveting session. Thank you so much for your time. That episode brings season 1 of Advocates, the podcast, to a close. We hope you have enjoyed listening to it as much as we have had making it. But the journey does not end there. Keep following us on our social media pages, recommend us to friends, and do please give us a 5-star rating on your podcast platforms. If you keep following us on social media, you will also see loads of activity, giveaways, competitions, which includes a chance to win an internship with some of our guests. And best of all, you will get news about season 2. What I can say now is that it is a lip-smacking cast. Stay tuned. We'll be back season 2.
Listen to the voices of the advocate.